For those who don't know me, my name is Claire Harrison. I'm the Managing Director of Harrison's, a HR consulting firm. And today's session has been very popular. It's back to basics around pay and award compliance. So we do have many people on today. So it is a little challenge for me in terms of being able to get that full gamut of people that have limited experience versus the more advanced HR practitioners of those that are on the webinar. So I will do my best to cover that full range. We only have 20 minutes together. So it'll be at speed and I'll give you as much information as possible. I suggest you take notes. There may be some time for questions, but feel free to get in touch with me later on. Okay, so disclaimer, I'm not a lawyer. We're not a legal firm, so we're not giving you any legal advice, nor am I giving you advice that is specific to your organisation. A little quick summary of Harrison's for those that don't know. So we offer consulting services around HR, workplace relations and leadership. We offer an outsourced, insourced is how we explain it, HR team service for small to medium-sized organisations. We have a recruitment and onboarding service, mainly around professional and executive roles. And My HR Experts is our online subscription site that's full of all of the recordings from these HR Bite sessions, other webinars, tools, templates, and you can access advice when you need it. Okay, so what we're going to cover today is the overarching workplace relations system in a snapshot, because that's not really our focus, but important for you to understand. Modern awards, getting your classification levels right within those awards, annualised salaries, IFAs, and the boot, and award and compliance checks. And as mentioned, I'll do a quick demo of how we do that with clients as an example. Okay, before we get into the workplace relations system, the Fair Work Ombudsman, who most of you would realise is hot in terms of proactively investigating, but also dealing with complaints about underpayments. So in the 2023-24 year, the Ombudsman recovered $473 million in unpaid wages for nearly 160,000 workers across Australia. More recently, in the last 25 financial year, they saw another $358 million from 249,000 workers, and that was following investigations and compliance activity. So over the past 5 years, they've recovered $2 billion, more than $2 billion, for underpaid workers across Australia. So interestingly, and maybe no surprise given what we see in media and the cases that come out, a significant proportion of these recoveries have come from larger corporate employers. But, you know, the interesting point for us there is they're the organisations that would have, we assume, or do have the sophisticated HR and payroll systems and expertise in place, but yet they're facing compliance challenges. So this enforcement trend is one of the reasons why pay and award compliance has become such a critical governance issue for employers today. Just a little bit more on that. This will be no news to anyone. We've all seen the high-profile underpayment cases involving large national employers, which have highlighted the risks of getting award coverage, classifications and salary arrangements wrong. The Fair Work proceedings against Coles alleging that approximately 7,800 salaried managers were underpaid around $115 million. That was due to salaries not being adequate to compensate for the award entitlements, specifically mostly around overtime and penalty rates. Similarly, the federal court ordered Woolworths to pay $50 million penalty for widespread underpayments involving thousands of salaried employees under the retail award. So these are recent cases that highlight the critical compliance principle of paying a salary does not remove awarding obligations. We cannot say someone is highly paid, well above the award rate, therefore we don't have to comply with the award conditions. So these cases really demonstrate that, but that is something that we hear often from our clients and employers. So employers must still ensure that the salary levels of employees are better off overall compared to the award. In practice, this means employers must assess actual working hours and entitlements within the pay periods rather than assuming the salary covers everything. That's an important outcome from these cases, and we'll see if that gets overturned in the next year or so. But they spoke about basically the boot needs to be met within the pay period rather than annualising it. More recently, workplace laws have strengthened even further. So from 1 January 2025, new federal laws introduced using the closing loopholes. Reforms mean that intentional underpayment of wage is now a criminal offence under the Fair Work Act, which worst case scenario means 10 years of imprisonment for individuals and corporate fines of up to $8.25 million. So the criminal offence focuses on intentional conduct, but even unintentional underpayments can still result in significant civil penalties and back pay obligations for employers. So for employers, the message from regulators and the courts is clear. Award coverage, classification and salary compliance must be actively monitored and regularly reviewed. So today's session at speed, we'll walk through the core building blocks of pay and award compliance and the obligations to meet the risks of underpayments. Okay, so quick overview for those, and I think most people would be aware of Australia's workplace relations system. So at the top is our Fair Work Act 2009, and there's a Fair Work Regulations as well, 2009, which govern the employee and employer relationship in Australia. There have also been various amendments to the Act, including closing loopholes, both 1 and 2 of those. Under the Act, all employees have the national employment standards that we need to comply with, and then we have modern awards. So National Employment Standards and Fair Work Act, absolute minimum. The modern awards set out the minimum conditions for particular industries and or occupations, including pay rates, penalty rates, allowances, overtime and classifications. Some workplaces have enterprise agreements in place as well, which is a negotiated agreement between employers and employees, maybe unions, maybe by industry that I'm not going to go into today, but these must pass the Better Off Overall test as well against the modern award for them to be approved. Finally, many employees also have employment contracts which outline the individual terms of employment, but these cannot provide less than the NES or the applicable award. It's a national system. There are some, caveats to that, but Western Australia has some different coverage for certain employees. And look, and this slide doesn't even mention all of the other laws that employers need to comply with, like Work Health and Safety, Workers' Comp Discrimination Acts by state and federally. But today we're focused on award and pay compliance. So let's get going on that. So modern award coverage. So there are 122 modern awards in Australia. And when we're looking at coverage, the first thing that we do is we look at the coverage section of the award. So, and often to do that, we also need to look at the definitions section as well. So generally, awards fall into 2 categories, being an industry award or an occupational award. So an industry award covers employees working in a particular industry, such as hospitality award, retail, building, and the SHADS award. And then there are occupational awards covering specific occupations across industries, for example, clerks, professional employees award. There are some awards that are both industry and occupational awards, such as the manufacturing award. One of the most common mistakes is applying the wrong award. You cannot choose which award you are covered by. It's not a matter of which one do I think is best for business. It is a matter of which one is right under the modern award definitions and coverage. Assuming that no award applies is a mistake. So like I said before, we often hear we pay people well above the award, therefore they're not award covered. That is incorrect in the majority of situations. So even a well-paid engineer is award covered by the Professional Employees Award. Look, and I'm talking in generalisations, but that is the case. And just be careful about using the miscellaneous award. It has limited applications. It only applies really where an employee is not covered by another award and performs the type of work that traditionally would be covered by an award, but generally that does not include managers. Because award coverage can be and is very complex, and it's important to use the tools. There's Fair Work has a Fair Work award finder, or seek professional advice to get it right. Incorrect award coverage can result in systematic underpayments, which we've seen highlighted in many cases and often with clients as well. And once you have it wrong, it's difficult to roll that back, and there's back payments that potentially apply to that as well. So that's modern award coverage. So as an example, this is just a screenshot from an award, which is the General On-Site Building and Construction Award. So if I'm deciding if this is my award, I go to section 4, which is consistently section 4 in all the awards, and first of all, what I can see here, 4.1 says it's an industry award. So just check that, because you'll see in Clerks Award or others, it might say it's an occupational award or other. So this is an industry award, and it covers people in this industry. Importantly, for this one, it goes on to explain what general building construction is, and this award actually has a number of different streams to it, so it defines each of those areas. So this is really important when you're doing determining award coverage, is to look at what the coverage clause in the specific awards are, and often there will be a definition that applies to the coverage as well to have a look at. So then we move on to classifications within the awards. Very tricky, can be. Once the correct award is identified, the next step is around correct classification of different levels. So each award includes a classification structure, normally in Schedule B, but that would be different. But normally Schedule B provides all of the detail and definition around that. So it's levels of jobs, basically, which is determined by skills, experience, qualifications, responsibilities, other areas. Each classification has its own minimum pay rate, which increases as the classification levels increase. A common mistake is relying on job titles rather than actual duties performed. So we're looking at the jobs, but also really importantly is the qualification required for the job, and it is actually required, not something that's nice to have. Also, other really important considerations are things like the decision-making capability within the role and supervision responsibilities. So misclassification is one of the most frequent causes of underpayments, particularly where employees have progressed in responsibilities, but their classification has not been updated. Best practice is to periodically review classifications, particularly when org restructures, roles change, responsibilities change, increase, employees are promoted, obviously. This ensures pay structures remain compliant with the award. Just some other considerations are, we did a large piece of work with a large client that, as we see commonly, so not just specific to this organisation, but had got into the habit of overclassifying their positions to enable higher pay rates. There's a big problem with that, is that that's difficult to roll back. So maybe times get hard and you want to bring them back. Putting aside, we're not going to decrease people's pay rates, but to bring that back to the right level, that is really hard to roll back. So you've got a cost there that the business doesn't need. Potentially the organisation becomes not as competitive. And also, that can breed to some inconsistencies within your organisation about same position but different pay rates. So, my quick advice there is to keep the classification right, but maybe make an over-award payment if that's what you're looking to do. So we always know the correct classification level. Also, pay increments apply in some awards, which is based often on years of service or hours, maybe for part-times. So you also need to know what that is. And juniors, in most awards, there are junior rates of pay. So there are increments depending on age. So we also need to think about that as well. This is an example of piece of work that we helped a client with. So this is Shad's award. This is just part of a larger document. So what we did for them to help them with classification is to really map out against the award the key things that we need to look at. This was developed with lawyer involvement as well. So really the starting point for this award and for this exercise was really around qualifications and knowledge, and then leading on to this area. So we had this for all levels of the SHADS award. We had to do reclassification of about 500 positions. So this was the basis on which we did that. So, you know, a nice way to map it out and see it really clearly. Another one that we've done recently in the Queensland public sector is, you know, this is the title. This is, and again, this is only part of a very large document, and there's more down here. But again, you know, differentiating supervision across each of these levels to determine the correct classification level. So important to get your head around that for your award or your agreement if that's what you're using. So we move on to annualised salaries, IFAs and boots. So when we're looking at annualised salaries, the first thing to consider is, does the award allow for annualised salaries? So there are some awards, but definitely not all awards that allow for annualised salaries. There will be a clause, sometimes an annualised salary clause, sometimes it's if you pay 20% above the highest rate, then you can buy out of these things. The Clerks Award has its own version of it. So every award is very different there. So important when you're thinking about annualised salaries for your award and covered employees is to look through the award to understand what does the award say about annualised salaries. If there is no annualised salary clause, then you should consider, it's normally clause 5 of most awards, which is individual flexibility agreements. So which only apply to specific award terms, but they will be the majority that you're looking at, such as leave loading, overtime, penalty rates and allowances. However, the key compliance requirement of any salary arrangement, whether it's an IFA or annualised salaries, is that the better off overall test needs to be met against the award. So what would have they earned if you were paying them completely against the award, considering penalty rates, overtime rates, allowances, leave loading? You need to be able to map that out based on their roster, what they have been working against. This is the salary that we're paying. And we need to show that under that salary, they are at least better off. So it's an exercise of getting all the numbers together, looking at rosters, actual hours worked, all information, you know, payroll records, time and attendance records that you need to be keeping for audit purposes. And if, you know, many of the annualised salary arrangements, they have a requirement every year to do basically an unders and overs. So we said this was the outer limit, but they've worked this. We didn't pay them for that. Therefore, we need to do a balance up at the end of the year. And I can't go into every award because they're all slightly different, but really important that you have a look at your award to understand the annualised salary arrangements that exist. And if you're going to use IFAs, they're, you know, done as a separate document to vary certain terms, but again, need to show the boot. So that failure to get this right and to monitor it, to test it ongoing, can create very large back payment liabilities, as well as, you know, penalties for getting it wrong from the Fair Work Ombudsman. I've just put a note here about guarantee of annual earnings. If you do have people that are at the high income threshold level, then that is something that you can definitely look at. But again, needs to be reviewed regularly and needs to be developed with contract at the beginning. Okay, so some key steps in terms of award and pay audit check. So like we've said, start with the award coverage, getting it right, start with the correct classification level, look at the wage rates against the minimum award. So each award, when you go into it on the Fair Work site, to the right-hand side, which I'll show you, has a pay guide that's the most up-to-date. You should download that and ensure you're on top of that, which includes all of these things. But in terms of, you know, looking to penalties, overtime and allowances. Allowances are in the pay guide, but these other penalties, overtime, you'll need to mostly determine from what's in the award. Then you need to, like I said, calculate the award equivalent and confirm the employee is better off overall. So this is just an example of those steps that we've that we have developed to help you work through that. So their classification, this is for SHADs. Find the pay rate within the latest version of the pay guide. So check to make sure you are using the last version. Check for all the additional allowances and penalty rates. Apply the overtime and penalty rates to the calculation. Calculate the final pay to determine if we're meeting boot. Okay, so just an example of where to find this, because I know people often don't know where to find this. This is on this little snapshot here is on the Fair Work website for this award. And over to the right-hand side, you just have to click on pay guides and it will bring a whole long list of all of the pay guides. But that is a download for you of all the current pay rates, overtime rates, penalty rates for every classification and different streams. So go through that. Okay, so this is a very simplistic example of an award and pay audit that we've conducted for a client. There is more information to the left that's been provided by the client around employee details, including hours of work and their current pay rate salary. So depending on the organisation or the positions, then often we also have to review their rosters, pay slips to determine correct application of the penalty and overtime rates and other allowances that need to be paid, which would be added into this spreadsheet to help calculate the boot. So we've got here the position. We've determined the correct award coverage. So you'll see this client has got multiple awards that cover them. Then we have determined their classification level. Then we put in the award rate, which a lot of these are calculating out. For the purposes of boot and what we know this client has told us and what is worked, we've put in 1.5 hours overtime here, and then we have in annual leave loading because they don't pay that separately, so we include that in the boot. We've annualised their allowances. And then this goes on to the second part. So we've annualised the salary. For casuals, we do the difference here, but for weekly rate for a full-time or for a salary or part-timer, full-timer, we have the difference in the weekly rate, and then this is the difference in the boot. And then we have some comments. So in this case, you'll see they're all coming up in the black, which means they're all meeting the boot, some not by much. So, you know, we just need to be really careful that we've included everything that we need to in there around allowances, overtime, penalty rates. And then for this client, we are using a mixture of IFAs and contracts for annualised salary arrangements. So that is an example of how that is done. So I've gone a little bit over, but in terms of how Harrison's could help, if you're looking at anything around pay, award and pay compliance audits, employment contract templates, annualised salary and IFA templates, advice to reduce wage compliant risk or anything in this area, please do not hesitate to reach out. If you have questions, haven't had time to answer because we were at 20 minutes, so I'm over that, feel free to reach out to me with these contact details or on LinkedIn. But I thank you very much for attending today and good luck with your award and pay compliance.